And with your expertise in the litigation and the kind of exposure you have, sir, it's very appropriate and very right point of time where people should be encouraged to go for the litigation. And I remember, sir, one stanza from the Mahabharata when the Yaksh asks Yudhishthir that what is the best path one should follow. And then Yudhishthir replies, Mahagano gatva sapata. The path on which the noble man and the enlightened one goes, that is something everybody should follow. And I can say to the students and to the younger generations are at this point of time that the way you moved from the judicial services to the litigation, that I encourage a lot of people to follow that, because ultimately it gives you a boost to your confidence, to the level and the way you have the knowledge. And that is something, sir. And you were I can say, one of the youngest topper of the Delhi Judicial Services. And also then you joined with the one of the leading firm in the litigation side, in the corporate litigation. And then finally you moved as an independent practitioner in the Supreme Court of India. And that path is something, it's a lot of people should and must, see a kind of encouragement and a kind of example in the market, sir. And with this, sir, I welcome you to the NLIU, and on behalf of myself and the faculty, I welcome you, sir, once again. Thank you so much, sir, for being here, joining us today. Thank you, sir.
Thank you,
To
Amit.
this,
Thanks, NLIU Bhopal, for having me. It's always a privilege and an honor. Are we good to go? Should we start?
Yes, sir, definitely. So before that, sir, I'll request the participants to switch on their cameras because it becomes more lively for all of us to see each other, and it won't be like speaking into the wall, sir. And if that is permitted, sir.
Oh,
def-
absolutely. Always
Yeah.
good to put a face to the name.
I again request all the participants to switch on their cameras if they can. We'll be recording this session, and I request Bharat sir to begin the session on behalf of the entire Student Bar Association.
Right, right. Thank you very much. Thank you everyone for showing up. I understand it's a Sunday, and we'll be discussing today the journey of a civil case. I am not going to have you open the barracks today. It's going to be fun and games. That's how we've tried creating it. Uh, I would at the very outset thank my colleagues Shreyash and Sushant who are here, who are part of the team, who've helped me put a few slides together. So what we've done is we are not going to get into the sections and the orders and the rules. There would be enough time for you to get into those, and those are important. Pair acts are important. What we've done is we've tried to cull out the first principles of civil law, and we'll try to take you to the fundamentals. We've also tried to put together some cool graphics. I really hope you find them cool as well. And if you do, please write it in the comments here. And if you don't find them fun enough, then find out Sushant and Shreyash on Twitter, and publicly you can let them know what your opinion is. So that aside, I'll just quickly cut to the chase and start with sharing my screen. Please give me a sign that you can see it. Uh, just a moment. Is this visible?
Yes, sir.
And am I audible?
Yes.
Perfect. So let's get started, guys. We understand, I mean, how is a civil case different from a criminal matter? We understand criminal cases are cases where a wrong is committed against the society at large. It may be murder, it may be hurt, it may be an NDPS offense, and so on and so forth. A civil case, on the other hand, is also a wrong, but more of a private kind of a wrong, where one individual commits a wrong against the other. Uh, it's important for us to appreciate this distinction when we are starting off. Let me start with this. These are the broad kind of cases that we see. Civil cases are cases, for instance, of a breach of contract. You get into a contract with somebody for purchase of a property or for rendering of a service or to buy a particular good, and the other person does not give it to you. That's a breach of contract. You can go to the civil court and seek damages. Civil cases also pertain to tortious wrongs sometimes, for instance, defamation and nuisance and other wrongs of tortious nature. The main point of a civil case and the consequences of a civil wrong are damages. If you commit a civil wrong, you commit a breach of contract, you may be made to pay damages and compensation to the opposite party. In certain cases, the opposite party can also seek against you what is known as an injunction, which is also known as stay in common parlance. For instance, there is somebody who's a neighbor of yours and who's creating a structure on his property that is blocking out the sunlight from your house and is also causing a lot of nuisance to you in terms of noise and is taking away your rights to enjoy your property. You can go seek an injunction. If somebody has agreed to sell a particular property to you and then goes on to renege on his or her promise and tries to sell the property to somebody else, then you can get an injunction. An injunction would be a court order to the opposite party, restraining that party from selling the property to somebody else and being held on to his or her promise. Another relief that you seek or a remedy that you seek in civil cases is specific performance, where a court enforces an agreement, and this is the case that we would take as the example in this presentation. So what we've done is we've visualized a fictional case with fictional characters, and in order to better demonstrate how a civil case moves, because we believe that it's better to show than to tell, and so that case is going to be a suit of specific performance of a contract. As opposed to this, there are criminal wrongs. We understand Indian Penal Code, NDPS, Prevention of Money Laundering Act, they lay down certain offenses. And these are broadly criminal cases. The consequences are different from a civil case. You can be imprisoned, there can be a fine, there can be even death penalty in certain cases. So these are the broad kinds of cases. Now let's zero into courts and their jurisdiction. That is the first question that the lawyer has to ask himself when the client comes, after the lawyer has understood the facts of the case, as to where would the case lie. Now, these are the broad types of jurisdiction in a civil case, and we'll dig deeper into each of those categories a little later. First is the pecuniary jurisdiction. Every court has the ability or the authority to decide cases of up to a particular value. For instance, if you're dealing with a property matter, you would have to see which court would have the pecuniary jurisdiction. All courts cannot deal with all kinds of cases. For instance, in Delhi, if you're going to a civil judge, if the value of the property involved or the value of the damages that you're seeking are more than 3 lakhs, you may not be able to go to the civil judge. You may have to go to the district judge. If, for instance, in certain states, the matter is very, very big in terms of the stakes involved, you may have to go to the High Court directly as well. So please understand pecuniary jurisdiction, pecuniary because value of the subject matter is important to be examined. Second type of jurisdiction is territorial jurisdiction. This is where you put to yourself the question, where should the case be filed? For instance, a case for a property that's located in Delhi can only be filed in a Delhi court broadly, and not, for instance, in Haryana or Bhopal. So that is known as territorial jurisdiction, because courts have jurisdiction only over their own territories and not beyond. The third kind of jurisdiction is also very, very important. This is known as subject matter jurisdiction. Civil courts cannot try anything and everything. There are limitations on their jurisdiction. Sometimes special courts are established to deal with certain kinds of cases. For instance, if you have a case which relates to the insolvency and bankruptcy code, where a company wants to go into bankruptcy, then you'll have to go to the National Company Law Tribunal and you cannot go to a civil court. For example, you have a landlord or a tenant dispute. That sometimes would only go to a rent controller, a special tribunal, and not a civil court. So you'll have to decide. For example, an election matter can only go to the election tribunals and not civil courts. Other classification for courts and their jurisdiction is on one side, there is original jurisdiction and the other is appellate jurisdiction. Original jurisdiction is when the civil case goes to the court for the first time. That is known as original jurisdiction. But once you've fought the case at the trial court level, and then one of the parties is aggrieved by the decision and they go on to appeal the case in a higher court, that is known as appellate jurisdiction. I'm going to dig deeper into this a little later, but this is broadly the five different things you have to keep in mind when it comes to jurisdiction: pecuniary, territorial, subject matter, and original and appellate jurisdiction. Now,
Bharat sir, if we can pause for a moment, sir. We have the Dean Undergraduate Studies of NLIU with us, sir, Professor Dr. Ghayur Alam. Sir, he'll take a brief moment, sir, to address the gathering, and sir, then we can continue.
Sure, I'll just come back in that case. And
yes, sir.
Mr.
Yes.
Bharat, has he left, Nipunj?
Sir, he's there, sir. He's there.
Mr. Bharat, good morning. My apologies for joining late. I was chairing another session in an international conference. So I also sought my apology there. And again, I'm apologizing here because of some time mismanagement at our end. So I, on behalf of myself, my Vice Chancellor, my students, my colleagues, extend a very, very warm welcome to you for being with us. And the point when I joined that you were discussing about the type of jurisdiction. If there are first year students, I was yesterday only or day before yesterday, I was telling them meaning of jurisdiction, types of jurisdiction, and other things. So it will be a great help for all these students and all of us to have the practical insight. Look, one of the problems with us is that we are teaching law for decades, but do not have any experience whatsoever of the real working of law in the court. And that is the legal system that we have, that a full-time teacher cannot practice law. So that hampers the education system itself. So the only way out is that we invite people like you to interact with our students so that they can get the practical exposure. So I'll not stand much between you and the students and participants. I once again welcome you, Mr. Bharat, and hope that it will be a meaningful discourse this morning. Thank you very much, and thank you, Nipunj, and thank you every participant. Thank you.
Thank you
Thank
very
you
much,
so
sir,
much,
for
sir.
having me. Those are very kind words. I'll try to be worthy of those. And you made a great point on academia and legal practice. Uh, I personally think that coming back to academia or to teaching adds so much to my legal practice as well, and the other way around, where you learn so much about being a lawyer from what you do in the classroom, and you learn so much about law in the courtroom, and you bring it back to the classroom, and both blend in so beautifully together. So
That is what I say. That is what I say, that we are discriminated against. That judges and lawyers, they can come to the classroom, but we teachers cannot go to the courtroom. So there's a great discrimination that we are facing. Maybe that we do not have a lobby which can lobby with the lawyers and others. That look, if the law teachers in US and UK can practice, why not the law teachers in India? So that we can bring our students to the courtroom, we can do the transactional practice, and then only the real clinical legal education will come into picture. So thank you, Mr. Bharat Chugh, and welcome you once again. Thank you. Thank you.
thank you very much, and let's hope there is some progress in that direction. I'm completely with you on that. I'll quickly, Nipunj, with your permission, switch back
Yes, sir.
to where we
Yes.
were and get back to the presentation. Right. So we've seen this already. Now, just to come down to the broad fundamentals or essentials of what a suit is. The first point, I think, which is important and is the important starting point of the parties to a suit. Every civil case would have parties, and those parties would primarily be the plaintiff and the defendant. Plaintiff who comes to the court asking for a relief, coming to the court with a grievance, and the defendant who's somebody who's accused of having committed either a breach of contract or any other civil wrong. There may be more than one plaintiffs, there may be more than one defendants. That's something we'll examine in what cases those joinders can be done. And I'm just flagging this for the time being, there is a concept of necessary parties and proper parties that you would read in the Civil Procedure Code. Uh, Necessary parties are those parties without whose presence the suit cannot really be decided because their rights and interests are involved. For instance, if you are filing a case of partition of a joint family property, you should have all the parties before the court. Or if you are filing a case against co-owners, you should have all of them before the court. It's not that you can sue one and a case can be decided in the absence of all the others. So those people are known as necessary parties, without getting into too much detail. Then there is a concept of proper parties, parties whose presence allows the court to decide the case in a more comprehensive manner. Then there is something known as a representative suit, which is very similar to how PILs are or how class action suits are. Sometimes a huge body of individuals may be aggrieved by one wrong committed by a defendant, and they can have one person agitate their grievances on their behalf before the court. That is known as a representative suit. You'll look at that a little later as well. We talk about PILs being a new phenomena or a phenomena that has come up in the last couple of decades, but even CRPC, more than 100 years old, has a concept of a representative suit. Then there is something in CPC which tells you that if you don't join a party to a suit, what is the implication? Or if you join somebody who should not have been a party, what is the implication of that as well, is also something you would have to keep in mind. Once you figure out who the party should be, for instance, if you are getting into a contractual action, you are complaining that there is a breach of contract, you would make the party who signed the contract with you as the defendant. If somebody's defamed you, that person who's published that article on the internet or written that column in a newspaper should be the defendant. So you'll decide those parties. Now, what is the subject matter? After parties, you'd look at what the subject matter of a suit is. Subject matter is nothing but, simply put, the property or the contract or the right to which the suit relates. For example, if it's a partition suit, then the properties and the estate is going to be the subject matter. A subject matter is nothing but on what and for what the case is being fought. The third term again is cause of action. Very important for you to understand this. We use it all the time. A cause of action is nothing but a set of facts or legal theory that gives an individual or entity the right to seek a legal remedy against the other. So my colleagues have put up this graphic where this gentleman, hardly a gentleman, who's trying to hit somebody, and the fact that he's hit another person with that table is something that gives a cause of action to this lady here, who goes to the court as the plaintiff and prosecutes the defendant or files a case for a tortious wrong, an assault or a battery or hurt. So just to recapitulate, the facts which the plaintiff must prove in order to succeed in the case is broadly what the cause of action is. Very important for one to understand this. This is also used in another sense, the material upon which the plaintiff relies in order to ask the court to arrive at a conclusion in its favor. Cause of action. It's the very heart of a case. I'll take the example of a suit for specific performance. A suit for specific performance is nothing but one party, two people getting into a contract, and the other party, one party to the contract does not perform his or her side of the obligations. This compels the party to go to the court asking for specific performance. Specific performance is nothing but holding a person on to his or her promise. You've gotten into a contract, you'll have to perform the conditions of the contract. When in all cases of breach of contract, there is broadly an option with the plaintiff. Either you can go to the court and get the contract specifically enforced in the same terms. For instance, if you contracted to purchase the property, you can go to the court and ask the court for a direction to the defendant that the defendant should sell you that property itself. Or the plaintiff can, at his or her option, seek damages in lieu thereof. You can say, okay, you had to sell me the property, but I'm okay with not getting the property now. Please pay me damages because you've broken your promise. Right? That's the broad distinction between a suit for specific performance and damages for breach of contract. The cause of action, which is that essential bundle of facts which are necessary for a plaintiff to establish in order to succeed, are as follows. First, you'll have to prove before the court that there was a contract that existed, existence of a contract. Second thing that the plaintiff would have to prove is the breach of that contract. Because if there is a contract but it has not been broken, there is no cause of action. The cause of action arises only once it is broken. And third thing that you possibly have to prove is that you as the plaintiff are ready and willing to perform your side of the bargain. So these three things would have to be proved in a case for specific performance. I'm just giving this by way of an illustration. Let's move further. Let's take a defamation case, for example. What would the cause of action in a defamation case be? So defamation is nothing but opening somebody to ridicule or lowering somebody in the estimation of the right-thinking members of the society. It is something that is damaging to somebody's reputation. In a defamation case, and defamation is both a criminal wrong as well as a civil wrong. For instance, in a civil matter, if you go in for a defamation case, what would you have to prove? Number one, publication of material. That the defendant actually published something, wrote something, said something that is defamatory in nature. So number one, publication of material. Second would be material being untrue is also a part of the cause of action, because truth is sometimes or most of the times a defense to a defamation case. And third, of course, the material being defamatory. It should not just be any material that is published, because sometimes as part of your freedom of speech and expression, you have the liberty to say certain things, liberty to criticize, liberty to comment fairly, and everything that you say about somebody is not necessarily defamatory. These three things would have to be proved by a plaintiff in order to, broadly speaking, succeed in a defamation case, and this would constitute the cause of action. To distill what a cause of action is in a case, you would have to go back to what the substantive law is. We all understand that laws such as Civil Procedure Code, Indian Evidence Act, Criminal Procedure Code, all these are procedural laws. They do not really tell you what rights and liabilities are, or what are the rights that you have. They only provide a machinery or a framework or a platform on which those rights can be realized and enforced. They are procedural. Now, what are substantive laws? Very important for you to know substantive laws. Substantive laws are laws such as Indian Contract Act, Specific Relief Act, Indian Penal Code. These are the laws which are substantive laws, which really tell you what the rights and liabilities are, but they leave the machinery of enforcement to a procedural laws such as CPC or CRPC. So in order to find out what the cause of action is, you'll have to go back to a substantive law. Moving on, so we've so far discussed three broad essentials of a suit. We've talked about who the parties can be, what is the subject matter, what is a cause of action, but none of this is going to be of much importance unless we talk about the release. Because you go to the court if a right has been violated in order to get a remedy, in order to get a relief, right? Where there is a right, there is a remedy. And without a relief, without what you actually want or desire out of it, none of the procedural laws are of any importance, right? Relief is what actually effectuates your right and gives you something tangible. You can get damages in a civil suit, damages compensation, monetary recompense for the wrong that has been committed to you, really. You can go in for specific performance of a contract, as I just spoke about a little earlier. You can go in for declaration in certain cases. A declaration is nothing but a court declaring that you are entitled to a legal character or right as to any property. For instance, somebody is denying a person's paternity in order to deprive that person of his or her property. The person can actually go to the court and ask for a declaration that I am the legal son or daughter of so and so. So those declarations can be sought. Somebody is trying to deny that you are entitled to your property. Then you can go to the court and get a declaration where the court declares that this is who the owner is and this is what the legal character is. And very important, you get injunctions in civil court. An injunction is nothing but a direction by a court for the defendant to either do something or to refrain or restrain from doing something. For instance, in this graphic that my friends have put there, somebody is trying to get an injunction because an asteroid is due to strike in 1 hour. So injunctions are a very powerful remedy or a relief, but I'm not sure in case of an asteroid going to strike the planet, you can get an injunction, or even if you get one, whether it would be of any tangible use. So that aside, you can also go to court sometimes in another kind of relief, which is known as rescission and cancellation. For instance, somebody gets a contract executed from you, placing you under undue influence or misrepresentation or by fraud. In all of those cases, you can go to the court and ask to be set free from your contractual obligations and for those contracts to be cancelled. These usually kick in cases where the contracts are either voidable or void. So in case of void agreements, voidable contracts, you can go to the court asking for rescission and cancellation. You'll read that when you go to contract. So I've discussed the broad 4 elements: parties to a suit. Please keep in mind subject matter, cause of action, and what is the relief that you are asking. With that, let me quickly shift gears to what the life of a civil case is in terms of stages. So the first stage of institution of a suit, or when you really set the process into motion, is the presentation of a plaint. A plaintiff files a plaint asking the court for certain release. Then it leads to service of summons of the defendant. Now, if somebody's filed a plaint, of course, you can't decide it in the defendant's absence. That is natural justice, right? So you would send summons to the opposite party, telling that opposite party, who's the defendant, that there is a case against you that you are called upon to answer. Please file your reply, which is known as a written statement, in 30 days so that we can decide this case. Then the parties appear. Both the defendant and plaintiff appear before the court. If either of them do not appear, then the case can be proceeded with in their absence also. But let's assume they do appear. Then the defendant files a written statement putting in writing his objections to the case of the plaintiff, legal objections, factual objections. Then there is production of documents by the parties. I'll share this presentation with you, so no need to, take notes and trouble yourself with it. After the parties have produced the documents that they rely upon, then the court gets into a dialogue with the parties in order to understand what the case is really about. At that point, court also explores the possibility of an amicable resolution by way of any of the ADR mechanisms. ADR is alternative dispute resolution, mediation, arbitration, conciliation, lok adalats. The court is empowered to send the case to any of those alternative means if the court sees that the parties may settle amicably without it having been called upon to decide on merits after recording evidence. However, if there is no amicable resolution, then the parties can get into discovery and inspection of documents. For instance, if you are the plaintiff, you want to rely upon a document which is in the possession of the opposite party, you can request for that document by way of discovery. You can try to inspect, because in all cases, you may not be having the requisite evidence in your possession that is necessary for you to pursue the case. Then there is something known as admission and denial of facts and documents. We'll get into that a bit later, where one party gets the other party to admit certain facts and documents. Because whatever that you admit in a court of law, that can be taken against you. And admission and denial does nothing but narrow down the point of controversy. Once all of this is done, then the court frames issues. An issue is nothing but a question that the court puts to itself and to the parties. And that is the question that the court has to decide at the end of the trial, after appreciating evidence, after appreciating documents. It's nothing but, you can visualize it like a lamppost or as guiding light, which keeps the parties focused, which keeps the court focused. And for example, in a case of specific performance of a contract, the issue would be whether the plaintiff entered into a contract with the defendant, whether the defendant breached the contract. Simple issues such as this, which would help the court decide better. Then you get into summoning and attendance of witnesses. Once the court has framed the issues, now we know with certainty that these are the questions that the court is going to decide in this trial. These are the contentious matters on which there is a dispute. Then both the parties would call on their respective witnesses, who would come and enter the witness box and would be cross-examined and re-examined to try and prove their respective cases. As I said, then there is a hearing and examination of witnesses, then final arguments, finally the judgment on the case. Then once a judgment is passed, the court prepares what is known as a decree, which is nothing but a formal expression of the judgment. It is an executable form of the judgment. Judgment is nothing but the court's decision and the reasons for those decisions. And the reason for that decision, why did the court believe the plaintiff and not the defendant? The court is going to lay out its mental process on how it arrived at that conclusion. Once the judgment is pronounced, then it leads to drawing up of a decree. Visualize decree like a document that is a formal expression that plaintiff is entitled to so and defendant has to pay so and so money to the plaintiff. What this does is that if the defendant does not comply with the judgment, then the plaintiff can take this decree to what is known as an executing court and get the court to help plaintiff get the fruits of the decree or realize the amounts by either selling the defendant's assets or putting him behind the bars, so on and so forth. We'll come to that. Of course, after judgment and a decree, the parties can challenge the decision in multiple ways, and then execution. So these are the broad, stages. There is some amount of overlap. Some of the stages may not apply in certain cases, but I'm just taking a simple vanilla civil suit and telling you these stages. We'll come to this slide a little later once again. So this is the stage. Now let's get to the practical. If somebody comes to you with a civil case, how do you approach? Of course, you start off by interviewing the client, trying to understand. Once you've understood what the case is broadly about, then, as I said, you would have to examine what the place of suing should be. So some of our divine friends here may have unlimited general jurisdiction, but normal courts, human courts, do have limitations in terms of their jurisdiction. For instance, as I said earlier, you'll recall that every court has a pecuniary jurisdiction. What is the value of the claim? And depending on the value, it may go to a certain court and not go to the other courts. Then there is a territorial jurisdiction. For instance, if it is a case relating to immovable property, it has to go to the courts of the place where the immovable property is situated. If, for example, it's a compensation or it's a case involving compensation for wrong done to a person, it has to go to a place where the wrong was done or where the defendant resides. Section 20 of the CPC, I'm not going to make you read all of that. Section 20 of the CPC says that in suits of other kinds, for example, contractual matters, you would file the case where the cause of action arises or where the defendant resides, works for gain, or carries on business. This would be your first inquiry. What should be the place of suing? How does the hierarchy of courts work? So what you have on your screen here is a broad hierarchy of courts. At the top, of course, there is the Supreme Court. Then there is High Court. Now you have to just focus on the civil side, okay? This chart also has criminal courts, but we'll look at the civil courts. For example, starting with the left, if you are in a metropolitan area like Delhi, Bombay, then you would have on the civil side, courts of smaller causes and city civil courts. If you are in a non-metropolitan area, then come on to the right side, district and sessions court, where on the civil side you have district courts, you have sub courts, a senior civil judge, you have the principal junior civil judge court, you have the munsif's court. This is how it is. Don't trouble yourself a lot with this. Different states would have different nomenclatures. All you need to understand is that there is a district court, there's a high court, there is a supreme court. Most cases start with the district court itself. Within district court, you may have civil judges and district judges. And in some cases, high courts also are courts of what we call as original jurisdiction, where a case directly goes to the high court. So you'll have to look at it from court to court. No need to trouble yourself with it as of this point. Now you've got a case. What are the things that you need to keep in mind before you draw up the plaint? A plaint, as I said, is where and how a civil case starts. For instance, a criminal case starts with registration of an FIR. A civil case starts by filing of a plaint. What do you need to write in a plaint? You need to write the name of the court that you're going. You should write the name of the parties, the plaintiff and the defendant, parentage, residence, their backgrounds. You need to very clearly write the facts constituting the cause of action and when it arose. It is important for you to say when your cause of action arises because of limitation related issues. You'll realize that it's not that any civil case can be filed at any given point of time. There is something known as a law of limitation, which obligates parties to go to the court within a certain period of time. For instance, if you are suing upon a contract, it's important for you to go to the court within 3 years of breach of that contract, for instance. So you need to write that in your plaint. You need to write down the material facts, not everything that has a relation to the case, only things which are material, which are critical to the outcome and which are relevant. Then you would have to tell the court about valuation and court fee. If you're filing a civil case, and this is another thing that differentiates civil cases from criminal matters, is court fee. In a civil case, you need to go to the court and pay court fee because you are taking the services of the court to enforce your contract, and you have to pay a court fee. And you have to also value your suit. For instance, if you are, and this valuation goes back to the pecuniary jurisdiction aspect. For instance, in Delhi, if you are suing with respect to properties running into 20 crores, you would have to go to the high court. But if the property is 2 lakhs, you may go to the civil judge also at the trial court level. So valuation, how do you value it? There are rules that would tell you how suits are to be valued under the Suits Valuation Act. You will have to say how much court fees have you paid. There are various ways of computing what court fees needs to be paid. For instance, let's assume the court fee is 1% of what you are claiming. For instance, if you're filing a case of 10 lakhs, you'll have to pay 1% of that amount as court fee. I'm just giving you an example. You need to write that in your plaint. You would have to demonstrate to the court, how does the court have jurisdiction? For example, if you're coming to a court at Bhopal, you will have to tell the court that the properties on which or for which I'm suing are located at Bhopal. That is the reason my lords have come to you and you have jurisdiction. For instance, if you are talking about a case where you've been defamed by a newspaper article, you can go to the court where the newspaper is circulated or published. And then you'll have to tell the court, that is the reason I'm coming to you, because the wrong has been committed in your jurisdiction. Or if a contract has been not performed and was to be performed in one city, you can say that I am going to courts of that city because that's where the territorial jurisdiction lies. Then, of course, you'll have to tell the court what are the reliefs you are claiming. Along with the plaint, you would also file all the documents on which you rely upon. That's very, very important. Because if you don't file the documents on which you rely upon, you may be barred from filing them later. And when you are approaching this as young lawyers, please talk to your clients and work with them extensively in order to understand facts, in order to gather the relevant documents and prepare, and strategize for every scenario. And you can't just file a plaint in the court and then see that evidence does not measure up. When your client is telling you the facts, you need to probe your client, cross-examine your client to get all the facts and the documents out, and then draw up a plaint. Other things that you need to keep in mind while drawing up a plaint is ensure that you are within limitation. I just spoke about this briefly. Every case has to be filed in a certain amount of time. Ensure you do that, and otherwise your case may be sifted out at the very outset or thrown out at the very outset. Ensure jurisdiction, I've already talked about it. Ensure that you are taking all the claims and reliefs emanating from a cause of action. What do I mean by that? For instance, you have a tenant who has not paid rent to you for the last 1 year. But you go to the court and ask for arrears of rent only for 6 months. And then after you filed the case and you've succeeded, you suddenly realize that I have sued for outstanding rent only for 6 months, whereas a rent of a 1 year period was actually due and payable. Can you file another case to recover those remaining 6 months? The answer may be no, because Order 2, Rule 2 of the CPC that you will read later obligates you to take all the claims and the release emanating from a cause of action in that single suit. So ensure that you are making your suit comprehensive and asking for all the reliefs and all the claims. Also to be kept in mind is that you should rely on registered documents and properly stamped documents. Many cases are lost out in the courts because the parties rely on unregistered documents. When you read the Registration Act, you would realize that many documents are required to be compulsorily registrable under the law. And many documents are compulsorily to be stamped under the law. A stamp is when you pay a part of, a part of the amount on the document to the state as revenue. So ensure that you rely on properly registered and stamped documents. Otherwise, these documents may be inadmissible in a court and your suit may get, or your plaint may get stuck. Also ensure that your case is not covered by an arbitration clause. That's very important. In most commercial contracts these days, there is an arbitration clause, and wherever there is an arbitration clause, the case cannot go to a civil court and it has to go to arbitration, and the jurisdiction of the civil court stands excluded. So look at the contract carefully. It's a contractual matter. If it is arbitration, you can't come to a civil court normally. Further, ensure that there is no bar to a civil court entertaining your case. As I said, very important. If there is a specialized tribunal set up for deciding the case that you are agitating before the civil court, then you should go to that tribunal and not a civil court. For example, an election matter or an insolvency matter. Moving on, now let's just get started with the sample case that I spoke about. So my friends have chosen these two gentlemen as the parties to the suit, and what they are getting into is a contract, and this is Tom and Jerry, and Tom is a plaintiff here in our case and Jerry is the defendant, and they got into a contract which was not honored by Mr. Jerry, and that has compelled Tom to come to the court in a suit for specific performance of contract. Let's quickly see what is Tom's case here. What does his plaint say? So what we've done is we've imagined some very simple facts and tried to create a plaint so that you can see how it plays out. So this is how a plaint, which is why or how Tom comes to the court in the first place to ask for relief, looks like. For some reason, Tom and Jerry here are in Bombay. So the matter is going to the Court of Civil Judge in Mumbai. There is a suit number. Then there is a title of the case in the matter of so-and-so. Suit for specific performance of an agreement dated 22nd June 2012. Plaintiff is Mr. Tom and defendant is Jerry. So this is what Tom would normally write in a plaint. And these are the facts that you have to assume. The plaintiff above named states as follows. By an agreement dated 22nd June 2012, executed between the plaintiff, who's Tom, and the defendant, Jerry, the defendant contracted to sell to the plaintiff an immovable property called Blackacre for a sum of rupees 2 lakhs. So here there is a agreement to sell for a property. Tom says further, as agreed on 11th of August 2013, the plaintiff offered 2 lakhs to the defendant and demanded that the transfer of the said property be done by way of a sale deed. But the defendant, who's Jerry, backed out of the agreement and did not execute the sale deed. Okay. So here you have somebody who agreed to sell a property but later backed out of the deal. In para 3, the plaintiff further states that the plaintiff has been and is ready and willing to pay the purchase money. The said agreement, fourth para is important, the said agreement was executed in Mumbai and the property in question is also situated in Mumbai. The defendant also resides in Mumbai. The fourth para is important to make out jurisdiction. Para number 1, 2, 3 are all facts, and para fourth is what gives the court the jurisdiction. Fifth is also important, and this is just a sample thing that we put together. A normal plaint is going to be more sophisticated and more formal. Para 5, the value of the subject matter. You would recall what the subject matter is. In this case, the subject matter is going to be the property or the agreement. The value of the subject matter of this suit for the purpose of jurisdiction is 2 lakhs, and it is the same for the purpose of court fee. Sixth para is going to say the suit is within limitation. You have to file cases within 3 years. So Tom says that it is within limitation. Plaintiff is further saying that I'll rely on the documents, a list whereof is annexed as A. Then 8 is very, very important, where the plaintiff asks for some relief, that the defendant may be ordered to transfer the said property to the plaintiff by way of a sale deed. Here you are asking for specific performance of the contract. 8B is also interesting, where the plaintiff also says that in the alternative, if the court is not going to give me specific performance, the defendant may be ordered to pay to the plaintiff rupees 2 lakhs as damages for breach of the said contract with interest. So if you're not giving me specific performance, please give me damages that I've suffered, which I quantify at so and so amount. And the third is the defendant may be ordered to pay the costs of the suit. So this is how Tom has drafted his plaint. Now there are some problems with this, but this is the broad landscape of a plaint. Finally, after you've talked about the jurisdiction, the facts, and so on, you have to give the verification clause. This is how the verification clause reads. I, Tom, the plaintiff, do hereby declare that what is stated in paras 1 to 4 are true to my own knowledge, and what is stated in the remaining paras is stated on information and belief, and I believe the same to be true. This is known as a verification clause, where you are telling the court that what I say is absolutely true according to my own knowledge, or what I've been told by people, basically to impose a duty of saying the truth upon the parties. Then you say, okay, I'm declaring this at so and so date. Then you sign it. Then there is an oath commissioner or a notary public who attests it that yes, this person has taken this oath or made this verification in my presence, and that official also countersigns this. Okay, so this is how broadly a plaint would look. Quickly turning to how things would pan out next. So the plaint is filed. Tom is before the court that Jerry is not selling me the property. Now the court will send summons to the defendant. Okay, how does the service of summons play out? Service of summons with plaint upon the defendant. This can be done in some ways. One is a court process. So what the court does is, it has got Tom's plaint. It would send one of its officials, a bailiff or a process server, as that person is called, a court employee, who would go to Jerry's house and give him the summon and say that you've been served. And also give him a copy of the plaint so that he can file a response within 30 days. Then there is something known as a dasti copy, where in addition to the court sending a summon to the defendant, the plaintiff himself can also take a copy of the summon and give it to the defendant himself. This is usually done to expedite things in urgent matters. If the defendant is not found at his house, then he can be served through family members as well. Then there is something known as substituted service. If the defendant is not being found, you can paste the summon at the out of his house, or you can make an announcement, or you can carry it in the newspaper. You can also send it by registered post or courier. Now there are certain judgments that say that you can also email or WhatsApp it. So these are the ways basically to let the defendant know that a suit has been instituted and the defendant should be answering to what the allegations is. So now, I've taken this example in our case. How would the summons to the defendant look like? This is how a normal summon would look like. In the court of so and so, in the matter of so and so, this is the suit. Whereas Tom, the plaintiff, has instituted a suit against you for specific performance of an agreement to sell, you are hereby summoned to appear in this court in person or by a pleader duly instructed, and to answer all material questions relating to the suit, who shall be accompanied so and so. This is the date on which you have to appear and answer the claim, right? And this would then have a date. Then it would be signed by the judge concerned. Okay. This is how the summon would look like. What next? So the defendant needs to file a response to the plaint within 30 days of the service of summons. This is very, very important. So if some of you are defending someone who's just got a summon from the court, you have to quickly prepare a reply, a written statement, which has to be filed within 30 days of service of summons, or up to 90 days if the court permits. That period can be extended. In fact, in some extraordinary cases where you have sufficient cause of not being able to file your response or your written statement in 30 days, the court can allow you even after the 90 days. This response that the defendant files, which Jerry would file in our case, is a written statement. Now, there are some broad rules on what a written statement should have. A written statement should have responses to everything that the plaintiff has said. For example, our plaint says that there was a contract for sale of this property called Black Acre. Money was paid or tendered. Still, the sale deed was not executed. Now, the defendant in his written statement should answer whether there was a contract or not, what was the date fixed for performance of the contract, was money paid or not, what was the reason for not carrying on with the promise, what was the reason or the justification of breach of contract, so on and so forth. The written statement should answer all of those. You also need to keep in mind that a written statement should have specific responses and denials to each allegation. It can't be vague or evasive. For instance, if the allegation against the defendant is that you accepted bribe in room number so and so of hotel so and so, then the defendant cannot come and say that it is denied that I took bribe in room number so and so of hotel so and so. The defendant should come forth and say that I did not take any bribe at all, not just in this room or this hotel, but at all. So your answer or your response in a written statement should not be vague or evasive. It should be specific. It should be to the point. It should also set the right context, or should put your narrative out there on what the real facts are. Please bear in mind that anything that you do not specifically respond or deny may be taken to be admitted. Very, very important. For example, you do not respond to an allegation that is leveled against you in the plaint. In your written statement, the court may take it to have been admitted by you. So very important for you to answer everything. Then file all the supporting documents that you have. If you do not file all the supporting documents, then you may not be able to file it later and you may lose that opportunity. Also, there are certain objections that you can take as to why the plaint is not good or not maintainable. You can take all those objections also in your written statement, and you should. So let's quickly jump to what the defendant in our case files in form of his written statement.
Sir, a minute, sir. There are questions. Can we reserve those questions for the end, or can we allow?
What I'll do is I'll quickly at least end this segment, and then I can get on to those. Since I'm on the presentation, I can't see those questions.
Sir, so they have requested to and do it after the presentation, sir.
If that is okay.
Yes, sir. Definitely, sir. You can continue.
Sounds good. You can keep noting down your questions or putting them in the chat box.
Yes.
Yeah. So this is how the normal written statement would look like. For example, here the defendant admits that the agreement referred to in para 1 was executed. Defendant really agreed to sell the property. But here the defendant says that the sale had to be completed and the purchase money was to be paid by a certain date. And time was of the essence. It was important that the bargain is completed by this date, but it was not completed. This is the defendant's story. Plaintiff's story, you would recall, was that we got into an agreement. I paid you money, offered you money on a given date. You still did not give me the sale deed. Defendant, on the other hand, says that the date was much earlier. If our contract was June, you had to pay the amount by August 2012. You tried paying the amount in 2013. And this is what the defendant says, that the plaintiff was not ready with the purchase money on the aforesaid date, as a result of which, on the 15th of August, uh, 2012, the contract was rescinded by agreement. Both the parties decided that you can't pay the amount. Therefore, we are putting an end to the contract in 2012 itself. So when you are saying that you paid me the money in 2013, that's a lie. That never happened. The sale had to be concluded in August 2012 itself, which you did not. And that is the reason we did not go ahead with the contract. In fact, defendant in para 3 is denying here that any amount was tendered to him at all. Okay. And then defendant is taking the standard objection that the plaintiff is not entitled to release, the suit should be dismissed, the defendant will rely on the documents, so and so, they annex their documents. Same drill, verification, whatever I'm saying is correct, and so on and so forth. So this is broadly a plaint and a written statement. What are the challenges that a person can take to a plaint? You know, in certain cases, if your plaint is not carefully drafted, it can be rejected at the very outset. For instance, if you do not disclose your cause of action properly, your case appears to be barred by limitation. You have not valued your case properly. You have not put the requisite stamp and court fee. Your case is covered by an arbitration clause. Your case is not of a civil nature, but relates to a public law issue or a purely religious issue, which is not something you can agitate in a court. Jurisdiction of a civil court is barred. Territorial jurisdiction is not there with the court. For instance, here in our sample case, the property was located in Delhi, but the case is filed in Bombay. That may entail a return of plaint, and one may argue that there is no territorial jurisdiction. And finally, you can also challenge a plaint by saying that the issue already stands decided. Now, that is very interesting. You would read res judicata in CPC, where res judicata is nothing but that the issue stands decided. For instance, Tom in our case had already gone to the court asking for specific performance of the contract, and the court had dismissed his claim. He cannot file a new case again after 6 months, because whatever stands decided is decided with finality. You cannot reopen it. You know, you cannot re-agitate the same case over and over again. So if it was a second case on the same cause of action, same issues, you can take the objection of res judicata also. So here Shresh and Sushant have added this, which says, cats are famously known, the myth says, to have 9 lives. But just because you have 9 lives does not mean you can file another plaint in each of your lives, and you cannot sue the same case or agitate the same case at 9 points in your life. So this is where we are. I'll stop here for a moment on the broad fundamentals and take some questions, and then see if we have time to get on to the other issues.
So there are 2 questions in the chat box.
Yeah. Okay, so Rohan has asked a question on list pendants in relation to India. So a great question, Rohan. Slightly, it's a longer discussion. List pendants is nothing but if there is a property which is subject matter of a suit, for instance, this property in my example, Black Acre, if during the pendency of this case, because this case is going to take a long time to get decided, if during the pendency of this case, Jerry, who's the defendant and the owner of the property who had to sell it to Tom, sells it to a third party, okay? And tomorrow the plaintiff succeeds to get the property in his favor. Then the doctrine of lis pendens says that any sale of a property that happens during the pendency of a case is subject to the outcome of the case. So, it's a longer discussion. I mean, lis pendens is something that one can talk about for hours and hours. We'll take that up. Then there is Devansh's question, is there any hierarchy of relatives on the basis of gender when the summons are served to the family members instead of the defendant? Now, I think the CPC says that you can serve it on an adult member. It does not get into a question of a hierarchy. So you can, for example, if the defendant is not found at his address, you can serve it on a relative of the defendant, any adult relative of the defendant. I don't think it gets into a discussion on who that relative should be, as long as that is, of course, your immediate family is the most preferable. Your spouse, your parents, your children if they are adults, and siblings, so on and so forth. So I think if that's okay, I'll just quickly get back.
I have a related question, sir. So there is a provision in CRPC which says an adult male member of the family. So is that not applicable here?
That's a great question and a very keen observation. CRPC indeed says adult male member, but I think CPC says adult member. So there is a distinction there. I think now, even in CRPC, we should make that amendment. There is no reason for it to be only an adult male member and not just any adult member. And I think we should possibly make it more gender neutral there. Yeah. Do we quickly jump back to where we were? So we've just talked about the, Nipunj, you can hear me, right?
Yes, sir.
Now, once those pleadings are complete, there is a plaint that has come in, there is a written statement, then what next? Then you can look at what is known as amendment of pleadings. For example, you have stated something in your plaint or a written statement, and you want to say something more. You missed out on certain facts or you committed some mistakes there. Then you can always apply to the court to amend your pleadings. So bona fide errors of typographical errors, clerical errors, arithmetical errors, all of those can be amended later. But don't, as a young lawyer, bank on the ability to amend. Amendment of pleadings is always at the discretion of the court. Try to ensure that there is no need to amend and you have stated all your important facts at the very outset. Then during the pendency of the case, you would also be seeking interim injunctions, interlocutory orders. For instance, in our case, when the defendant agreed to sell to the plaintiff the property called Black Acre, the suit is going to take a long time to get decided. What happens to the property in the meanwhile? What if the defendant sells it to a third party? There, the CPC, in Order 39, Rule 1 and 2, Section 94, allows a party to seek an interim injunction where the court can direct the defendant not to sell the property to a third party. These injunctions stay alive during the pendency of the case, and these are protective orders, these are preventive orders to ensure that the subject matter of the case is duly protected. So you can seek those injunctions also during the pendency of the case. Then once the court has got the plaint and the written statement, then there is examination of parties by the court. The court tries to understand what the case is about. Then the court explores the possibility of an amicable settlement. Now, this is not the kind of out-of-court settlement that the court would send you to. It would almost never be pistols at dawn. This is more like it, where two parties, the plaintiff and the defendant, are trying to resolve their disputes through mediation. There is a third party sitting there who's trying to get the parties to find common ground and to amicably resolve the matters. It is not that if you've come to a civil court, you cannot amicably settle the case and finish it, you always can. The court can give you an opportunity. Cases are always referred to mediation, and if the parties come to a settlement, for instance, in our case, if the plaintiff and defendant agree that the property should be transferred, or in place of this property, some other property can be given to the plaintiff to compensate him, or some amount of money can be given to compensate him, and that would satisfy him. All those solutions and all those formulas of resolution can be explored in mediation. And if you go to mediation, or you go to arbitration or conciliation, and your matter gets decided there, then the court is not required to conduct a trial. And the inclination of the court would always be to amicably resolve the matter, and not go on for a trial. For instance, here I think the mediator is suggesting that we can agree that it's a big backyard. Both of us can, if we are fighting over space, let's try to find out a practical solution and not fight about it. So as I said, if the court sees possibility of an amicable settlement between the parties, it may refer the parties to arbitration, conciliation, judicial settlement through lok adalat, mediation. And if there is no amicable settlement, the matter proceeds to certain pre-trial procedures or framing of issues. What are these pre-trial procedures? Discovery, as I said. If you have certain documents that you want to rely on, but they are in the possession of the opposite party, you can seek discovery. You can seek inspection. You can administer what are known as interrogatories. If you want to ask us a few questions to the opposite party in order to understand their case better, or to get some facts out of them, to elicit some facts out of them, you can administer interrogatories to them. Then there is something known as admissions and denials of facts and documents, where you get the opposite side to admit a fact. They may admit or they may deny. Then there is an examination of parties by the court. The next issue, which is crucial, and we are now drawing towards a trial and towards the end, is the framing of issues. When the court is framing an issue, as I said earlier, the court is framing a question that is necessary for the court to decide in order to finally adjudicate this matter. For instance, in this image, what is happening? The chaff is being sifted from the grain. The gentleman in the picture is trying to sift the relevant from the irrelevant. That is what the court seeks to do at the time of framing of issues. There might be many issues between the parties, but all of them are not relevant. All of them are not important. So the court, after it has all the documents, it has all the pleadings, it has the affidavits, it would go on to frame issues. This is how those issues are framed. Some sample issues, obviously not to be relied upon in your cases, but just as representation. For instance, first issue may be whether there was an agreement between the plaintiff and the defendant. When I say OPP, it means onus of proof on the plaintiff. Now, this is not an issue that needs to be framed. You would recall that the plaintiff is relying on the agreement to sell the property, and the defendant is not even denying that agreement. Since there is no denial by the defendant of the agreement, it is not an issue at all. It is admitted. So when something is admitted, you do not need to frame an issue. You do not need to frame a question on that point. So this issue may not be framed, and that's the reason we struck it out. But a valid issue may be whether the sale of the property was to be completed and purchase money to be paid on 11th of August. Since defendant is saying this, OPD, onus of proof, burden to prove this fact is on the defendant. Very important for you to keep the rules of burden of proof in mind, because whoever bears the burden of proof bears the obligation to prove a certain fact or an evidence. So for example, defendant is saying that the contract had to be completed by 11th August 2012. The onus of proof is to be on the defendant, and that is the issue that the court has to decide. Another issue may be whether it was agreed between the plaintiff and defendant that time should be of essence of the contract. Defendant is saying that it was a very time sensitive contract. It had to be completed by 11th August 2012. And since it was not completed, the bargain is off. So since it is defendant who's saying it, the onus or the burden is on defendant. Whether the plaintiff was ready and willing to perform his part of the contract, onus of proof on plaintiff. Very important. You've come to the court asking for specific performance. You have to prove to the court that you've been ready, you've been willing, you are not the person who's broken the contract. Then defendant argues that the contract was rescinded by mutual consent on 15th August 2012. Since it is the defendant saying it, the defendant has to prove it that after the plaintiff could not make the payment on 11th of August 2012, they put an end to the contract mutually. Let the defendant prove it. This is the question that the court would decide, one of the issues. Then there is an issue whether the plaintiff paid 2 lakhs, which the plaintiff alleges that he did. Whether the plaintiff is entitled to specific performance of the said agreement, again, plaintiff has to prove. Whether the plaintiff is entitled to any damages, and if so, what should be the quantum of the damages, again, onus of proof on the plaintiff. And then the court is going to say no other issues arise. Parties to file list of witnesses within 15 days with an advance copy. So the court has done what here? The court has looked at the pleadings and the court has said, okay, on the basis of these pleadings, I would be answering these 7-8 questions. Please now come with your witnesses who may be able to throw light on the matter and who may be able to help the court in understanding the case better. So each party, after the framing of issues, both the plaintiff and the defendant would have to file a list of who their witnesses are going to be. You would recall when we were looking at the image, when Tom and Jerry are shaking hands over the agreement and signing the agreement, there's another gentleman who's present there. So that gentleman may be a good witness in this case, right? So this is what issues are. Once the issues are framed and the parties file their list of witnesses on who their witnesses are going to be, then the question is trial. How does trial take place? In our judicial system, we fortunately do not have trial by fire. It's not that we would make the plaintiff and defendant walk on burning coal or embers and see if they are able to pass that ordeal. And if their feet or the bottom of their feet don't get burnt, they are saying the truth or they are lying. This is not how we decide cases anymore. Actually, this is how we used to decide cases centuries back. But now we have a more sophisticated way of doing it. Is this how we decide civil cases in India? By jury members, ordinary lay men and women who decide if the case is good or not, whether it's the plaintiff who's saying the truth or is he lying? No, we don't have jury trial either. We decide the trial before a civil judge who would call the witnesses, and the witnesses would come. First, we'll have the plaintiff's witnesses who's Tom. These witnesses would be called as PW1, PW2, which means plaintiff's witness number 1, plaintiff's witness number 2, plaintiff's witness number 3, so on and so forth. And the documents relied upon by each witness may be labeled as PW1/1. That is the first document that the first witness relies on. PW1/2, so on and so forth. And the same thing for Jerry. They would call their witnesses. In a civil matter, all these witnesses would not come to the court in the witness box and say what their story is. As per amendments in the CPC, now they would have to file their deposition, their witness statement in the form of an affidavit before the court. Okay, so now evidence in civil cases is not recorded by calling the witness to the witness box and having the witness say his or her story in the way that they want to orally. No, in order to save time, the code now dictates that you have to file what is known as your examination in chief on affidavit. You must have seen this in the movies, that you come to the witness box and say what your story is. In civil cases, that's not how it happens. It comes on an affidavit. However, the cross-examination, the questioning of the witness by the opposite party in order to find out the truth, which is done by the opposite party, is done orally and in court or through a court official who is known as a court commissioner and so on. So you have witnesses, you've called them, they have filed their affidavits in the court, they are cross-examined. Cross-examination is nothing but trying to discredit the witness, demonstrate to the court how the witness is lying by asking the witness some leading questions. Then, of course, at the stage of evidence and trial before a judge, there is a re-examination. So if you've got a witness, for example, the plaintiff, Tom in our case, gets that gentleman that who was standing there as a witness to the agreement and who comes to the court and says, indeed, yes, this is the agreement. This is what the defendant agreed. This is how the money was paid. This is how the defendant broke his part of the bargain and did not sell the property. All of that would be said by the witness for Tom in his affidavit, and then the defendant's counsel would cross-examine. And then there is another opportunity for the plaintiff to try and re-examine his witness. For example, your witness has been thoroughly discredited in the cross-examination. You can ask the court for permission to re-examine the witness to try and get some semblance of credibility onto the witness. It is known as putting Humpty Dumpty back together again. For example, your witness is Humpty Dumpty and in cross-examination is fallen off the wall. In re-examination, you can try and redeem your witness. You can try and get the court to believe in your witness by demonstrating to the court by questioning that your witness is indeed truthful and is not a liar. Then there are other objections that you take in a court of law. We see this day in and day out. You say the question is irrelevant or the document is irrelevant. You say the question is inadmissible or the document that this opposite side is relying on is inadmissible. You say that there is an objection as to mode of proof. For example, the opposite side is getting a photocopy of a document or a printout of a document and not the original document. You can take an objection on that also. Once all of that has happened, pleadings are complete, issues are framed, evidence is done, then the court pronounces a judgment, which is nothing but a concise statement of what the case is. You remember we framed issues, which were the questions that the court put to itself. Then the court would go on to decide each of those issues and give its findings. Then the court would say what were the points of determination, what were the tricky issues that arose in the case, then the decision on it, and the reasons for such decision. Reasons, of course, being the most important, because that's the heart of a decision. Justice should not only be done, it should be seen to be done. And it can be seen to be done only when you give the reasons for each of your points. And that's important. Once the judgment is pronounced, then you have a decree. I'll just show you how the judgment in this case would look like. This is how the court would say, this is my judgment. These are my findings on each issue. So each of those issues we framed, the court would say, I agree with it or I disagree. I find this issue in the affirmative, which means I agree with it. I find this issue in the negative, which means I do not agree with it. They would give findings and then go on to award the damages or go on to award the relief, okay? And then the judge, of course, is going to sign and say, what did he grant? For instance, in this case, the judge grants the decree of specific performance and says that the defendant Jerry is directed to execute a sale deed for the suit property in favor of Tom and also pay damages of 15,000 with interest of 8% and cost of the case. So the plaintiff succeeds in this case. This is how the decree is going to look like. So judgment is an elaborate discussion on what the case is, what the evidence is, and what are the reasons. The judgment that I just showed you, I'll just come back to it for a moment. This is not really a great judgment because it only tells you what is the finding of the judge on each of those issues, but it does not give you the reasons on why the judge believes that issue 5 has succeeded. The court should say, this is the evidence that the plaintiff has got before me. I agree, this is credible to me. There is no reason to disbelieve the plaintiff. The plaintiff has also been subjected to cross-examination. He has come out on top. He has withstood the test of cross-examination. There is nothing to show that he's lying. And the court has to give all of those reasons, which is known as appreciation of evidence. All of that is not there in this judgment by the great learned civil judge Sheldon Cooper here. So this judgment is possibly going to be open to challenge in an appeal because it does not give you the reasoning part. It does give you the finding and the result finally, but it does not give you the reasons. It does not show you or demonstrate to you the mental processes by which the decision is arrived at. It does not show why the court believed one side and did not believe the other. But moving on, when you have a judgment for good or for bad, the court would draw up a decree. A decree is going to look broadly like this. It would be a very brief document. It would say that the suit came up for disposal before me. So and so counsels appeared. It is declared that the plaintiff is entitled to specific performance of the agreement. It is ordered and decreed that the defendant will execute the sale deed in favor of plaintiff. also pay a sum of so and so as damages with so and so interest rate, and also the cost of the suit, because the plaintiff has also expended money in the prosecution of this case, and all those costs are to be paid to the plaintiff. And this is what the court says. Now, what do you do with this decree, and why do you need to have a decree? You need to have a decree because you need a single document that you can take to an executing court, because you'll have to remember that the defendant Jerry here may still refuse to comply with this decree. He may say the court has ordered me to execute a sale deed, but come hell or high water, I'm not going to execute. The court has ordered me to pay 15,000 as damages, I'm not going to pay, right? In that case, the plaintiff cannot just be left with a paper judgment, right? With a paper decree. This has to mean something for him. He should be able to realize the fruits of his decree, in which case he goes to what is known as an execution of decree, where Tom, who was earlier the plaintiff, has become the decree holder, and Jerry, who's the defendant, has become the judgment debtor, the person who has to comply with the judgment and who's a debtor under the judgment. There, the plaintiff can file, or the decree holder Tom can file an application for execution. Now, the application for execution can be filed wherever Jerry has assets. It has to be filed normally within a specified period of time, for instance, 3 years or 12 years, depending on what the case is. Then the plaintiff in an execution can also request that the defendant be asked to file an affidavit of their assets. This would be important because sometimes the plaintiff or the decree holder may not be able to find out where the defendant's assets are, their properties, immovable or movable, which can be sold. So that's important. All of this can be said. So this is your judgment debtor here. What are the different ways where you can recover money from him? You can ask him to deliver some of his property. You can attach and sell some of judgment debtor's property. You can also put him behind the bars if the defendant or the judgment debtor has had means to satisfy the decree. For example, he's a moneyed person, or a moneyed mouse in this case, who's got sufficient assets to pay the 15,000 that he has to pay to the decree holder, but is still not paying, is in willful neglect, is somebody who's still not complying with the decree. So in those cases, this person, the judgment debtor, can be also sent behind the bars in a civil prison for some time in certain cases. And you can also seek an appointment of a receiver. For example, your judgment debtor here has certain property. There you can, get somebody appointed, a third party appointed, to take the judgment debtor's property in his or her possession, and then use it or try to recover the amounts from that. So this is where we broadly are. Coming back a full circle, these are the stages that we started with. We started with the presentation of a plaint, then the service of summons on the defendant, then the defendant appears in the court, then you have filing of a written statement, production of documents, and then you have there is a examination of parties by the court to understand the case, exploring mediation, amicable settlements. Then you have discovery, which is where if you do not have a document which is important in your possession, the opposite party has it, then you can get the court's order to discover that document or get a copy of the document from the opposite party. Then you frame issues, which are questions which the court has to decide in the case. Then the witnesses come, they're examined, cross-examined, they're re-examined. Then you have arguments in the case, then you have judgment, then a decree is prepared, then an execution of the decree. So that's broadly the gamut. I'll leave you with that presentation. I'm mindful that we are running against time. Thank you everyone, and thanks Shreyash and Sushant for putting this together. I am happy to take questions now.
So there are two questions in the chat box, and then there are some more.
Sure. So I'll just take that. Devansh has said that in CPC there is a concept of Pardanashi women. Of course, it's there. In certain cases, CPC, unfortunately, is not as progressive or modern a document. For instance, you'll recall I was talking about a situation where a judgment debtor can also be sent behind the bars in execution if he's not paying up. But you cannot send a woman behind the bars in a civil execution because there is a protection there. So there are certain things in CPC where it is, a bit dated and regressive as a document, but that's again a different debate altogether and would take long. But I agree with you. Sanjeev Chaudhary ji is asking a question: should we annex the evidences in the plaint itself, or should we do it at the time of evidence? Sanjeev, that's a great question. Normally, you would file all your documents that you are relying on along with your plaint itself. Please look at Order 7, Rule 14, which says that all the documents you rely upon should be filed with the plaint itself. Otherwise, you may not be able to rely upon it. There are certain exceptions to it. For example, you want to rely on a document to cross-examine the opposite party, then you can reserve that document and not file it at very outset. You can reserve it for cross examination. For example, that is a document that you want to surprise the witness with, and you want to put it to the witness and see the spontaneous reaction of the witness who according to you is lying. Then you can reserve the document for later, but only in exceptional situations. For example, there is a witness that you know is going to come up from the side of the defendant, who's taken money from the defendant to give his evidence. Now you, by sheer fortune, have a document, a receipt that this witness has got money from the defendant. Okay. Now you're not required to file it straight away. In fact, if this witness comes to the witness box trying to help the defendant and depose in his favor, you can at that point put that receipt to him when you're cross-examining him and say, you are lying today because you've taken money for giving your evidence. You are not somebody who knows anything about the case. That is the reason your evidence is not something that the court should trust. And you throw that receipt at the witness in the cross-examination. That is possible. So you'll have to do a circumstantial assessment on whether some document should be filed or should be reserved. The normal principle is they should be filed, and it's essentially a matter of strategy and depends on case to case. Next question is by Mr. Chaudhary again. What is the difference between interrogatory and cross-examination? Again, a great question. Interrogatories are essentially nothing but a list of questions that you send to the opposite party asking them to answer. This is done before cross-examination. So there sometimes you would want the opposite party to clarify certain issues. You can send those interrogatories. But I would advise strategically that if you have some very good questions that totally discredit the witness and show to the court that the witness is untrustworthy and you want to catch the witness, it is better to take them up in cross-examination and not in an interrogatory. Because if you write those questions in an interrogatory and send them to the opposite party much ahead of cross-examination, then what you'll essentially do is you'll give the opposite party, an opportunity to draft and craft responses. Because the interrogatories mostly are answered not by the parties themselves, because the questionnaire is in writing and the answers are in writing. Those are usually drafted by the lawyers. So there you would lose the advantage of getting spontaneous responses from the witnesses, catching the witness by surprise, tripping him up on certain disadvantageous facts. So take that strategic decision on a case-to-case basis. Akshat has asked me a question. Good afternoon. Is there a difference between an order and a judgment by the court? If so, how can we determine the same? Is it like that the final decision is a judgment, and if there are further hearings, it is an order? Great question, Akshat. There is indeed a difference. An order normally, you appreciate the difference between a order and a decree mainly. In a civil suit or in the life of a civil suit, the court would have to decide on various interlocutory interim issues also. For example, the court has to decide whether amendment of the written statement has to be allowed or not, or whether a issue has to be modified or not, or the court has to decide whether an injunction should be granted in this case, or the court has to decide whether I should appoint a receiver to uh, take over the assets during the pendency of the case, or the court has to decide if an order of discovery should be passed or not. Should the opposite party be ordered to file certain documents on record or not? Many, many things that the court has to decide on a day to day basis while doing a trial. So, in all of those cases, while deciding those questions, the court doesn't pass a decree and write a judgment. The decree and the judgment would only come at the end of the journey when the court is finally deciding the case one way or the other on all the substantive issues, where the court is actually delivering a decision on the underlying case, on the rights and liabilities of the parties, and that is a substantive decision. Those are not procedural matters. So normally orders are passed with respect to procedural and interlocutory matters. Some orders are appealable, some orders are not appealable. Decree and judgment is something that would be coming at the end of it when the case is decided for good. Amit has asked me a question, so please elaborate on IAs. Amit, I'm assuming by IAs you mean interim applications or interlocutory applications. It's interlocutory applications is again a subject by itself. I'll just give you some examples on what the interim or interlocutory applications would be. In the case that we discussed, if the plaintiff feels that the defendant is going to sell the property, which should come to the plaintiff, because that is the bargain, during the pendency of the suit, and the case is going to take like 5 years to get decided, then the plaintiff can ask the court to pass an order of interim injunction in favor of the plaintiff, whereby the defendant is restrained from selling the property, restrained from leasing out the property, restrained from taking a loan on the property, anything that goes on to create third party rights in the property, and anything that is important to preserve and protect the property. Because if the end of a trial, the plaintiff succeeds that the plaintiff should have got the property, but in the meanwhile, the property is sold to a third party and then to another party thereon, then the plaintiff would not be able to get that property, right? Because there would be too many rights and liabilities involved. There would be a mess of legal relationships. So there you can get an interim injunction. That is one interim application. Similarly, there may be many. As I said, there may be one where you are trying to seek amendment of your case because you said something by mistake earlier. Or in a given case, you think that the defendant is going to run away from the jurisdiction. You can ask for an order of attachment of his assets even before the final decision. So many IAs, very interesting area of law. In the interest of time, I'll move on to the question by, I'll give opportunity to others also. Ms. Das' question, Sanjali Das. In a case where one party has made an appeal in court as per the pecuniary jurisdiction of the court, but the other party has also sued the previous party on some other issue and appealed as per territorial jurisdiction, what will the court do in such case? Like, how does an advocate choose to make an appeal as per pecuniary jurisdiction or territorial jurisdiction? Does choosing either have any advantage or disadvantage or affects the case in any manner? So I think you're mixing up two things. One is an appeal and one is the original filing of the case. The original filing of the case is always going to depend upon where the property is, where the cause of action has arisen, where the defendant resides broadly, or where the wrong was committed. All of these courts, as per section 16 or section 15 to 20 of the CPC, would have jurisdiction. There you may have some option, because more than one courts may have jurisdiction. You may choose to go to one and not the other by way of a strategic decision. So there you have a option, so to speak, as a plaintiff to go to one court. In pecuniary jurisdiction, you do not really have an option. If the case involves property of 2 crores, you'll have to go to a court which can hear it. And these you would find in the high court rules of your state on what court can hear disputes of what quantum, right? So there again, it is not much of an option here. But for instance, a case is filed in a court which did not have jurisdiction. Then the opposite party's obligation is to come to the court quickly and tell the court that it has no jurisdiction. Because if you do not take the objections of lack of territorial jurisdiction or lack of pecuniary jurisdiction, at the very first instance, there is a chance the court may say that you have waived your objection and you cannot take it thereafter. So these objections are capable of being waived. So the opposite party has to soonest come to the court and take those objections. And then, of course, if the court doesn't agree with you and the court feels that I do have jurisdiction, then at the time of appeal, finally, when the case gets decided, you can agitate that matter once again on jurisdiction. Then you'll have to make out a case that it actually led to injustice. So a court deciding a matter which it did not have territorial or pecuniary jurisdiction to decide has led to injustice, and you can take it as a ground for appeal. Then we have a question by Krishna Priya. Can you make additional claims by amending the plaint? I have come across written statements which state that the plaintiff not be allowed to add more claims by way of amendment. Interesting question. Normally, you can amend your pleadings only with a view to clarify matters, only with a view to provide facts to the court, some additional facts to the court, which you did not provide the first time around, which would help the court decide the case better. Normally, the court will not allow you to take up a new cause of action or to take up a new claim, which you never took earlier, by way of an amendment. Because you will have to remember that for the new claim that you are trying to take, that claim may be barred by limitation. You would also have to remember that when the plaint was filed, acting on that plaint, the defendant filed a written statement taking certain objections and taking a given stand. Now, if you go back and change your plaint, you are essentially changing the goalpost, right, for the defendant. And the defendant is prejudiced. The defendant is somebody who wouldn't like that, of course, because the defendant has already taken a position on oath on an affidavit. So there is a huge body of law that says what kind of amendments are okay, what kind of amendments are not. You may read the case of Revajitu Builders, which summarizes the law on amendment of pleadings. Normally, you cannot amend your case to include a time barred claim. You cannot amend your case to introduce a totally new unconnected claim. You cannot amend your plaint to take up something which amounts to going back on your own admission. For instance, in your plaint, you said that, yes, I executed an agreement, but you now want to amend and say that I never executed that agreement, right? You are trying to take away an admission you have already made on oath. That normally will not be permitted. There are different ways and scenarios, and please do read this case. It's extremely helpful and summarizes the law really well. A great judgment by Justice Dalveer Bhandari, very summarizes everything. Then we have a case, Mr. Sanjeev Chaudhary again. In case we need to enhance the amount we have been awarded in a case which is decided ex parte, what is the recourse? So just for everyone's benefit, if the defendant does not appear in the case and summons have been served validly, it's not that the court is incapacitated. The court can still decide the case in the party's absence and pass a decree, right? This is known as proceeding ex parte. You will have order 9 of the CPC on this. The court can proceed in the absence and go on to pass a decree. So in this case that Mr. Chaudhary talks about, the court has proceeded in the absence of the defendant because the defendant did not appear in the court despite getting the summons. Now the question is, can you enhance your amount or enhance your claim during the pendency of the case? For instance, when you filed the case, you asked for 20,000 rupees. Defendant is ex parte. The court is only asking you what your case is. Then you want to double it to 40,000, for instance. Can you do it or not? The question, in a single line, the answer is yes. But the court would ask you the question, why did you not take it up the first time? What was the reason? Was it a typographical error? Is this new claim even justifiable? And all of those inquiries would be done, and the court may or may not allow. It is very difficult to say without having the complete facts. Mr. Malhotra seeks to ask a question on the nature of CPC and requests to be unmuted. Can we do that? I'm okay with it.
Yes, sir. Yes, every participant is allowed to unmute.
Good afternoon, sir. Am I audible?
Yes, you are. Please go ahead.
Sir, my question is that what would be the exact nature of the CPC? Is it purely procedural or purely a substantive one or a mixed one?
So that's a great question. Normally, CPC is characterized as procedural because it gives you the machinery, as I said, on how your rights are to be realized and enforced. In many procedural laws, there is a substantive component as well. For instance, Indian Evidence Act, which tells you how the witnesses are to be examined, what fact is relevant, what fact is admissible, who can come and prove what, doctrine of hearsay, so on and so forth. Indian Evidence Act also may have certain provisions which amount to substantive, which gives you some rights. For instance, some people argue that the provisions of estoppel in Evidence Act may be in the nature of substantive provisions because they give you a right or something. That's an argument. So it is not as black and white as that. Largely CPC is procedural, but there may be some provisions in CPC which may be in the nature of substantive provisions because they give you a right or they take away a right, which is of substantive character. So, I personally think these issues to be matters of mere semantics in multiple ways. And it always boils down to what provision are you dealing with and whether that is procedural or substantive. And that sometimes becomes an important examination if, for example, you are trying to see retrospectivity. For example, by way of an amendment, the legislature is trying to take away a right or amend the law retrospectively. Then you will have to get into an examination as to whether that provision is procedural or is substantive. And depending on what your answer is, the amendment may be retrospective or prospective and so on. I think we've got another question. Amit has asked me a question. Sir, what are consent decrees and what stage can such a decree be asked for? Great question, Amit. Thank you for asking that. As I said, that during the pendency of the case, at any point, the court actively can encourage parties to amicably resolve. Okay. So if in a given case, the parties amicably resolve at whatever stage, up till, of course, the passing of the decree. At whatever stage they resolve the matter. For example, in our case, the sample that we discussed, the defendant agrees that I'm going to give the property to the plaintiff, or I'm going to give another property in lieu of this property, or I'm going to pay 50,000 as recompense. Then they can get into that settlement. Then the court, as per Order 23 of the CPC, Order 23, Rule 3, if I'm not wrong, can record the statements of both the parties, laying out the terms on which they are settling, and then finally sign off on it, and then pass a decree on the basis of that compromise, on the basis of that consent. And this decree, which is based on not a trial where one party wins and the other loses, but on a compromise, on a consent, on an agreement that the parties have worked out amongst themselves. And the court only places its imprimatur or its signatures or its authority on such a compromise and passes a consent decree under Order 23, Rule 3. It can be passed throughout the length of the trial. And once it is passed, it is executable in the same way as a normal contentious decree of the court.
So, just one related question on that, Amit here.
Yeah, go
ahead. Can a waiver of a particular right in question be also asked at, in a consent decree, or can a compromise be of such a nature that wherein you acquiesce to certain claims of yours, or any of these, sort of mechanisms which ultimately lead to an issue in itself, which was a framed issue, not being decided by the court, but also the parties giving up on their rights or obligations?
Interesting question, Amit. It would depend on what you are giving up essentially. Of course, when you're doing a consent decree, there is a liberty that you have on what the terms are going to be, and the court normally would have its hands off and would not actively intervene on what the terms are, as long as they are legal, as long as your agreement is a valid contract in the eyes of law for good consideration, consent is free, so on and so forth. In that agreement you say that certain rights are being waived. It would depend on what those rights are. It depends on whether they even relate to the subject matter of the case, because ultimately you are getting into the consent decree in a given case, in a given framework. The court would see what are you giving up. Can those rights be even given up under the law? Because not everything is waivable, right? Some things are waivable, other things are not. So court would get into the legality of what you are trying to do, and then either choose to give its consent or not give its consent. It's again very circumstantial.
So factors like unconscionability and all will play a factor, right?
Uh, Unconscionability is again extremely wide. I would say that one looks at again anything that goes on to make the consent vitiated or unfree, undue influence, coercion, misrepresentation, fraud, uh, person not being in the right state of mind, a person being a minor, so on and so forth. Those things which completely vitiate the agreement or vitiate the consent, or render the agreement that you are entering into as illegal or against public policy or immoral or whatnot, whatever is there in 23 and whatnot of the Indian Contract Act. If those things are attracted, then of course the court can refuse to, say yes to what you've agreed on. For example, in certain cases, the courts have said that a mother may not be able to give up the maintenance rights of the children in a case for perpetuity. That is something that we are not going to permit. So those, for example, you try to vest jurisdiction in a court which would not have jurisdiction otherwise under the law, or you try to get into an agreement which is specifically outlawed. So all those things would always be for the court to see. The court is not going to go into the question of inadequacy of consideration. For example, you may settle the case for a song. You may settle a big monetary dispute for a fraction of the amount. The court is not going to be bothered with what considerations is enough for you or is adequate for you or inadequate for you, unless it is the case where clearly it is undue influence or somebody has abused a dominant position. So again, very, very, factual and circumstantial. I've tried giving you a couple of different illustrations, and yeah.
Thank you so much.
So, with your permission, may this be the last question that Rishitosh asked. Are there any workarounds for res judicata?
Great question, Rishitosh. Res judicata again is an area that we can discuss for hours and hours and hours and still touch at the very tip of the iceberg. That's how vast the area is. What are the ways around? The ways around usually are from within Section 11 itself. Would depend also on whether it's actual res judicata or constructive res judicata that is being claimed. You can always argue that the first case, the court did not even have the jurisdiction. You can always argue in the first case, there are two cases, right? Case number 1 and case number 2. You are saying case number 1 already stands decided, so you can't start case number 2. You can always say in case number 1, this was an issue, which was only incidentally an issue and not directly and substantially an issue. You can say that in the first case, the matter could not have been agitated because the cause of action arose subsequently. You can say that multiple ways out of Section 11 itself. There are, I think, 6-7 explanations also to the section. Each of them have their own ins and outs. So I think some other day we should do one on res judicata itself and discuss this at length.
Yes, sir. Definitely, we can plan for another session, sir. So we have already planned for litigation master classes where we will be inviting practitioners, senior practitioners who will be teaching students about the nitty-gritties of the practice, sir. So with this, I feel we have extended about for 2 hours, and sir, I'll, on behalf of the entire university, the Student Bar Association, the Vice Chancellor, the Deans, and Professor Amit Pratap, I'll thank you for joining us for this brief session, sir. And I'll also thank all the participants from across NLUs, all the practitioners and academicians that have joined us. So this brief session, sir, I'd like to conclude by saying just one thing. So I read something very beautiful written somewhere in a book called Learning the Law. It was written that a person and basically a commoner goes to the court of equity and says, where is the criminal? Where is the murderer? But in a court of equity, you do not have a murderer. So this is the session. This is the kind of session where we learn that civil practice is specifically different, because for commoners, for the people who begin practicing or learning law, they think that every case must be a criminal. They're not that. That is not the situation. So thank you so much for making things, the basics of civil procedure, clear for us. This was a great refresher course for the senior students and a great beginning for those who have just started learning the law. Sir, a lot of requests are pending on my mobile phone for the recording of the meeting and the PPT. So I request you to share the PPT for the meeting with us so that I can mail it to the participants in the end.
Sure.
And
I'll
so
do
with
that.
with that, I'll request you to say some concluding remarks and then we can leave, sir.
Okay. Thank you very much for showing up on a Sunday. Had a good time. Great questions. Look forward to engaging with you more. I'll share the presentation. Happy to also take up questions. If there are any, please feel free to send them in by either the write-in section on my blog or email or whatnot, or route them through Nipunj. I'll try and answer them. And good luck and be safe. Happy holidays.
Thank you so much.